the third category, which is tenants in common. And what tenants in common mean is that each owner owns a 1/2 undivided interest in the property, but no right of survivorship, which means that if one spouse dies or one owner dies, the property doesn't automatically convey to the other owner. They own it basically separately with the right to fully possess and use and utilize the property as their own, along with the other owner or co-owner, but they don't have the survivorship rights. So in that case, if a husband and wife do own the property as tenants in common, which we do see from time to time, and one spouse dies, it doesn't automatically transfer to the surviving spouse. In that case, the spouse who passed away, the deceased spouse, their interest in the property will have to be probated, or there's also an expedited way to transfer it using an affidavit of succession if certain things are met, such as the value of their interest in the property is below 100,000 and they've been deceased for over 6 months, and there's a few other requirements. You could potentially transfer it with an affidavit of succession, which is approved by the probate court, but it's actually not a probate proceeding. But if those things aren't met, or you want to just transfer it in quicker than 6 months, within the 6 months from the date that the spouse passed away, then you're going to have to go and do a probate with the superior court and open a probate proceeding, have a personal representative appointed, and then they can convey the property to whoever the rightful beneficiary is, which many times will be the surviving spouse, but it's not a guarantee. It depends upon whether the deceased spouse had a will, whether they died intestate, whether they had children from another relationship. All of those things will factor into whether or not that property will eventually end up or their share of the property will end up with the surviving spouse.